This is WPSL Port St. Lucie, the talk of the Treasure Coast.
You're listening to WSTU Stuart. The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney StuartM Address.
Good morning. I'm Stuart Address, and this is Ask a Lawyer for July 23rd, 2021. I come to you from Florida, not yet part of the Confederate States of America. We'll see what happens.
The what?
Well, if we have another civil war, according to what I saw earlier this week, a map, Florida will be the southernmost part of the Confederate States of America.
No, Cuba's annexing Florida.
Well, you know that I may even need to learn Spanish, though.
Como se llama?
Sí.
Gracias. El Stewart.
That's right. El Jefe. El Jefe.
El Jefe. Oh, man. Oh, we're all going to get in trouble now.
That's right. Secret police will be at my door any moment, so let's stay on the air while we can. All righty. Well, you know, last week we were talking about a couple of the cases that I've handled throughout 35 years of history. It seems so long when I say it that way. I thought we'd go back to that topic because I started looking at some of the trials I've had, and some of them are just very, very weird. So I thought, you know, I would start with another one. And remember, folks, you can always call in if you have any questions or comments at 772-340-1590. I'm happy to be interrupted. But we're going to start with a case that I like to label, "You're a Spy." It's a case from 1991, 92, just before I moved to Florida. So the early 90s. And I'm sitting in my office as an associate in a very large Southern New Jersey law firm, doing civil litigation just like I do now. And I get a phone call, and it's a judge's judicial assistant in Camden County, where we're located. And she says, "You've been assigned pro bono to handle a case for a woman who we'll call Karen. Go meet with your client in the Camden County Jail." I said, "Excuse me? I don't handle criminal law. I'm a civil litigation attorney." And the judicial assistant said, "Well, your name came up in the ping pong ball lottery, so it's your client." I didn't even know they did that, but they did back then. And we all had an obligation once a year to handle a pro bono case, and I guess this was mine. So I follow the instructions, you know, even though I'm not a criminal defense attorney. And I get into my car, drive to the jail, which was attached to the courthouse. And I go into the jail door and I say, "I'm here to see a client. I've been appointed as her attorney." And they buzz me in, and they buzz me into another door and another door. And as I go through each door, the door behind me clangs shut. Now, mind you, I'd never been inside a jail before, so this was a little disconcerting. I know I'm being locked in right now. And I get to a point where they tell me, "All right, go down this hall to the elevator and meet with your client up on the third floor." Okay. I walk down the hall with my briefcase in hand. I get to the elevator. The elevator door opens up right away. Now that's pretty good timing. I walk into the elevator. I go to press the button to the third floor. There are no buttons. I start looking around the elevator to figure out, how do I get to the third floor? And I don't see any way to do it. So I step out of the elevator and I look up and down the hallway and there's nobody there. I go back into the elevator and I try even harder to figure out, how do I get upstairs? I walk back out of the elevator and still nobody in the hallway to help me. Go back into the elevator again, when somebody who must have been laughing on the other end said, "Where would you like to go?" Well, apparently in a jail, elevators don't have buttons. They control it from the control room. And you tell them where to go, you don't get to pick.
I was in an FBI office like that once in San Diego, man. It just freaks you out. I understand.
So you can relate. Greg says he was in an FBI office like that once, so he can relate. And I felt like an absolute idiot. I just knew they were laughing in whatever room they were in, monitoring. And finally, the elevator door closes, and I head up to the third floor. And right there's another security, desk, and I tell them the name of the client that I'm here to see, and they tell me to go sit in this location, and they'll bring her out to me. And she comes on out, she sits down, and she's been charged with two things. She's been charged with battery, and she's been charged with violating the court's restraining order. So I sit down and I tell her that I've been assigned to represent her. I'm her attorney. Just in case she doesn't understand what that really means, I explained to her that anything she says to me is privileged. I cannot repeat it to anybody without her permission. So she can tell me whatever she needs to tell me. And I ask her to tell me what happened, because her trial is next week. And she looks at me and she says, "You're a spy." And I'm like, "What? You're a spy?" No, I'm your attorney. I'm here to represent you. You're a spy. Well, so I asked, they always tell a lawyer, don't ask a question that you don't know the answer to on cross-examination. So I asked her, "What do you mean I'm a spy?" Well, apparently she'd been through the ringer and she'd been through the mill and was very well acquainted with the court system. So she proceeded to cross-examine me. And she said, "You've been appointed by Judge such and such, right?" "Yes." "And this is the judge that is trying my case?" "Yes." "And this is the judge who entered the restraining order?" "Yes." "And this is the judge who charged me with violating his restraining order?" "Yes." "You're a spy." Well, I got to admit, she had convinced me. It sure seemed like the deck was stacked against her. I was appointed by the very judge who was going to try her, charged her. I don't know if I would have told me anything. So I could not get her to speak with me. I left the jail and I went next door to the courthouse and I got in touch with the judicial assistant and said, I'd like to make a motion. Is the judge available? He said, "Yes, go into the courtroom and the judge will hear you." I go into the courtroom, wait my turn. And I say, "Your Honor, I move to withdraw from Karen's case." "Well, Mr. Address, why do you seek to withdraw?" "Your Honor, I just came from the jail and I attempted to speak with her so that I could prepare a defense, but she will not cooperate with me." "Well, Mr. Address, please explain." "Your Honor, She tells me I'm a spy. And the judge is befuddled and bewildered and says to me, "What do you mean you're a spy?" Well, I proceeded to run through the cross-examination that I had to endure. And I said, "Judge, she's convinced me I'm a spy. I mean, look, you charged her. You're trying her. And you appointed me. Would you tell me anything?" The judge chuckles. Judge says, "Motion denied." I said, "What?" And he said very sympathetically, "Mr. Address, if I grant your motion, I'm going to have to appoint another attorney. What do you think's going to happen? So you're in it. Go back to the jail. Tell her you're all she's got. And she could speak with you or not speak with you, but next week's her trial." So I trudge on back to the jail. But this time I'm a little wiser. I enter that elevator and I say, "Third floor, please." Good me. Fool me once, don't fool me twice. Go back up to the third floor. Sit down again. Wait for them to bring her out again. She comes back out. I said, "Look, Karen, I just came from the courthouse. I tried to get out of your case because you say I'm a spy. Judge says I'm all you got. So you could speak with me or don't speak with me. But if you don't speak with me, next week when they bring you into the courtroom and your trial starts, I'm not going to know any way to defend you." So I urge her to speak with me. And she finally relents and tells me her story. I go back to the office. I research. I prepare my case. We go into next week. It's time for trial. I go into the courthouse. And the state of New Jersey puts on its case against Karen with the charge battery and violating the court's restraining order from re-entering the home, which she and her boyfriend had an altercation. They put the boyfriend on the stand, and he testifies. And the state's attorney concludes his direct examination and says, "Your witness." And I get up, having prepared, having a piece of information that I was given by my client at my ready, waiting to utilize it at the appropriate time. And I take the boyfriend through the events of the day where supposedly, she committed battery upon him. And it's an interesting story because supposedly she hit him with his prosthetic leg. And her story is that it wasn't self-defense, and that he had used that leg against her previously. So I ask all my preliminary questions, and then I go, "Mr. Such and Such, would you please remove your left leg and show it to the court?" And the state goes, "Objection, Your Honor." The judge looks to the state attorney and says, "Well, what's your objection?" And he says, "I'm not sure yet, but there has to be an objection here."
What? Really?
That's really what happened. Objection, basis for your objection. I don't know, but I have to think of one. And the judge looks at me and says, "Mr. Address, what?" I said, "Your Honor, this is part of our defense of self-defense. I am asking Mr. Such and Such to remove his left leg and show it to the court." Counsel approached the bench. So this other attorney, the state attorney, and I go up to the judge's bench. And this is where, you always see attorneys whispering, except in movies you can hear them talk. And the judge says, "What is going on here?" I said, "Your Honor, Mr. Such and such has a prosthetic left leg. He has utilized that leg to batter my client previously. And her defense is that she got a hold of the leg and she raised it above her head in self-defense, prepared to strike him with it. And we need him to remove his leg for her story to have the ring of truth and to prove that, it's a prosthetic leg." The judge looks to the state attorney and says, "What do you know about this?" "Your Honor, I don't know anything about this. I don't know anything about a prosthetic leg." "Counsel, go back." We go back to our respective corners like in a boxing ring. The judge turns to the witness and he says, "Mr. Such and such, do you have a prosthetic left leg?" "Yes, I do, Your Honor." The judge thinks about it for a moment. Says, "Well, I'm not going to make him remove it. We're not going to turn this courtroom into a circus. However, I'm ready to make my ruling." And I'm like, remember, I don't practice criminal law. The state has not rested. I have not put on any witnesses. How could this judge be ready to make his ruling? And so I start objecting because I know even basic procedure, this doesn't work. Remember the story I told you last week, Mr. Address? It doesn't work that way. Well, now I'm the one saying to the judge, it doesn't work that way. Judge just shoos me and silences me with his hand and says, "Don't worry about it. I'm prepared to make my ruling." So we sit back and I have no idea what's about to come. And the judge says, "On the charge of battery, I find the defendant not guilty. On the charge of violating the restraining order, I find the defendant guilty and sentence her to time served." So she's going to be released now. Essentially a victory. She's getting out of jail. Wonderful. I mean, hey, I'll take the win, even if it comes in a weird procedural form. She's been pronounced not guilty. The state can't appeal. That's double jeopardy. So the judge just took control of the proceedings, even though maybe it wasn't procedurally proper, but he ended the case right then and there. And he sentenced her guilty to violating the restraining order, figuring, well, what's she going to complain about? She's being released. Sure enough, she's not happy with that. She turns to me, "I want to appeal." I said, "You want to appeal? You won." No, he found me guilty of violating the restraining order." "Yeah, but you were sentenced to time served. You're getting out." "I don't care. I want to appeal." "Well, ma'am, I was assigned for this case. You want to appeal, find yourself another attorney." And that was the end of that case. You're a spy.
So did this day end with the spy that came to dinner?
Oh, absolutely not. I was not inviting her to dinner. The spy may have gone home to her boyfriend, may have not have gone home to her boyfriend. I don't have the foggiest, but I was done.
Oh, man. Ah, okay.
Hey, when in a career, as I've gotten to this point now, and I sort of look ahead at, I guess, retirement is somewhere in sight. And I think back on the fact that I've actually had a 35-year career. Where did it go? I mean, where has time gone? To me, it feels like I just got out of law school. It doesn't feel like 35 years later. And so sometimes now you start reflecting on what has really happened during the past 35 years, the highs, the lows, the weird stuff, the fun stuff, people you helped, people you couldn't help, people you preferred not to help. You know, and you realize that you have some stories. And these are stories that some people around the family have heard many times and others have never heard. So, you know, they say old people repeat stories. You hear them over and over. Well, I guess that's true because I'm starting to get that complaint as well. All right. So since we don't yet have a caller, 772-340-1590.
They're all sitting home laughing that a judge would actually do what he did.
Well, they can laugh. Call me. Tell me what you think about the case. Tell me if you have a question. Tell me if you've ever dealt with a person with a prosthetic leg and they used it against you. I don't know. Whatever. All right. Until that happens, we'll go into what I call the case Snatching Victory from Defeat, or How to Prove a Dozen Teenagers Are Lying. This was a weird case which we prevailed on in a very unexpected way. This was a case that was local, about 17, 18 years ago. You guys can dig through the archives to figure out what it is exactly I'm speaking about, but there was a high school clerk that was charged with various charges relating to inappropriate conduct with minors. And here's the backstory. The teenager at the center of this dramatic story had babysitted the clerk's children from 10, 13 years earlier and had become a member, essentially, of the family. And she had been with them so much, and she had a dysfunctional family herself, that she had sort of become a semi-adopted member of the family, constantly babysitting the kids, constantly interacting with the family, having dinners there, spending the night, going with the family sometimes on vacations. And then she got to high school. And she fell in with the wrong crowd. And the high school clerk who worked at the high school realized what was happening and did not want that kind of influence around her kids. So in a way, she had basically communicated to the teenager that you cannot come around the house anymore. You know, I don't approve of things you're doing. And that started a campaign to get this clerk in trouble. So the clerk, whose eldest child is also in high school, goes to the prom, and she decides, for the safety of her kids and some of the others, to have an after prom party at her home. So they don't go to the hotel, they don't do all sorts of other things. Now, we now know today, parents, don't have these parties at your house, because if anything happens, you're the ones that are getting sued. It's a wonderful idea to protect your kids and, you know, have it at your house so that you know that people aren't drinking and driving, they're not leaving the house, you know, but you get in trouble with anything that goes wrong. So, you know, people now know not to do it. But, you know, back then, I guess it wasn't so clear that it wasn't a good idea. And she had an after prom party at her home, and she allowed her son to invite a number of guests. And of course, people in the high school heard about the party, and a lot of people crashed the party at her home. And of course, what did some people bring into the house? Well, beer, wine coolers. Now, she had her husband chase away a number of people, but you can't control everybody if you're not every place at all times. And there's a backyard, there's a living room, there's an upstairs. This is the problem. So the party finally concludes. It was a very disruptive party, a difficult party. She had to evict a lot of people. And a couple weeks goes by, and there's a knock at her door. You're under arrest. She's handcuffed, read her Miranda rights, placed in a police vehicle, taken to Rock Road, booked, placed in a cell, awaiting her first appearance to see if she can bond out. Spends the night in jail, has her first appearance, is released on bail, goes home. When she comes to the law firm I was working in at the time, the thing that I remember is her comment about the weight of the handcuffs. She remembered the heaviness of the handcuffs, how the handcuffs felt on her wrists. That was what was most traumatic for her. And it became a central part of our damages claim for emotional anguish. Her memory about the weight of the handcuffs. So we start with the discovery process, request for production documents, interrogatories, depositions. We had to depose about a dozen teenagers who were telling a story, and this was the story. Mrs. Clerk allowed kids to have beer and wine coolers and red Solo cups, and she even went upstairs with a few of the boys and had sex with them. Well, Mrs. Clerk was fired, as you could expect, from the school district and made headline news. And she was now a pariah. She couldn't go to the supermarket without people walking the other way. Felt isolated, humiliated. And we continued with discovery. And all the teenagers told the same story. The story was remarkably similar in terms of the way they told it, as if somebody had coached them. Maybe it was the teenager at the center of all this, but the one who had really pushed us forward was that teenager's mother. She's the one who pushed it with the school. She is the one who pushed it with the police. She is the one who made various comments that we believed were defamatory.
So not only a scorned teen, but a scorned teen's mom.
Yes, a scorned teen's mom. This mom, recognizing the dysfunctional relationship she had with her daughter, had allowed her daughter essentially to be part of this other family. And when she was essentially ostracized from that family, and she told her mother a story, the mother ran with it. So we're getting ready now for trial. And the attorney I worked with, we're both handling this case. He's going to handle certain parts, I'm going to handle others. So we're discussing the upcoming trial, and How are we going to prove defamation? How are we going to disprove that all these teenagers are lying? Or how are we going to prove they're all lying? Because there's so many of them. How are we going to prove each one of them is lying? And he says, well, don't worry about that. I'll handle the teenagers. You get ready to examine the girl, her mother, some of the experts. He's going to handle the teenagers. All right. I don't know how. I'm very concerned about it. So we start day one of trial. Now, day one of trial is always the same. You voir dire the jury panel. You ask a lot of questions to try to figure out whether they're going to be biased, prejudiced, favor one side or the other. What kind of bumper stickers are on their car? This may tell you if they're conservative or liberal, open or closed-minded, especially today. What magazines do they read? What newspapers? What news channels do they listen to? There are days worth of questions that you can ask depending upon the case. And my colleague was going to handle voir dire. In fact, he was really, really good at voir dire. And I didn't have a ton of experience with it. So I sat there taking notes of what the prospective jury individuals were saying in response to his questions so that we can eventually decide whether or not to challenge each individual for cause or use a peremptory challenge to strike them. So we conclude the first day of voir dire. It's not over with. And we go home for the evening and I get a phone call from him. I'm not going to be in court tomorrow. What? I have to go down to the Keys. What? You handle the rest of voir dire. Huh? And pick the jury. What? Thank you. Thank you for doing a day of voir dire and then telling me at the last moment that I'm going to have to finish it and then pick the jury based upon the responses, and you'll be back the next day for day one of trial. I was not a happy camper with that colleague, let me tell you, because it's one thing to handle it; it's another thing to have it thrown at you at the last second as a hot potato. So we went in day two. I did voir dire and I picked the jury, and he comes back and we start the trial. And finally we I examine the kid, and I tie her up here and there, and I examine the mother and I tie her up here and there, and I do the job that I believe I'm supposed to do, and to show the weakness of their story and the reason they may be fabricating a story. And the teenagers begin to testify on the defense case, one by one, by one, by one, by one. And my colleague cross-examines each one of them, same pattern of questions, getting the same responses. And I'm thinking to myself, this is not really proving anything. I mean, they're really doing a pretty good job in their defense of proving the truth that she gave alcohol to minors and had sex with minors upstairs. I mean, unless you're going to disbelieve each and every teenager, they're doing a pretty good job with their defense of truth. And to me, it's not looking really good. Well, how does the case turn? The case turns on one teenager who departed from the story, in such a manner as to cause the jury to disbelieve him and now the rest of the teenagers. And here's the story. This young man goes beyond the beer and wine cooler story and includes hard alcohol. Says he had drinks with the high school clerk at the home. He had hard alcohol. Well, do you remember what you had? Oh, yes. Goldschlager. Oh. And is there any reason you remember that? Oh, absolutely. Because I asked Ms. Clerk, what are these things in the bottle? And she says, well, those are Goldflecks. And he says, well, I came up with this idea. I'm going to buy a case of this Goldschlager and I'm going to sell the Goldflecks. Wow, that's pretty smart, huh? That's the financial analysis of a teenager.
Welcome to entrepreneurial spirit.
Yeah, except it's not entrepreneurial spirit 101. It's entrepreneurial spirit negative 999. Why? Well, I'm going back to I'm going to use the price of gold as of today. Trust me, it was a lot lower back then. Every bottle of Goldschlager has 0.0032 ounces of gold. Or grams, I'm sorry, not ounces, grams of gold in it. Yesterday, gold sold for $1,827 per ounce, or $5.85 of gold in a bottle. Now, you're also going to need to find a gold refiner that will process the gold. It's not a free service. So, given the price of Goldschlager, the idea of selling the flecks for your $5.85 is not a very good business proposition because you're going to lose a lot of money.
That sounds like the federal government.
So that story was so outrageous, outlandish, and so departed from the theme that everybody else was singing that the argument we made during closing arguments to the jury to disbelieve the teenagers. If you disbelieve Mr. X, Mr. Goldschlager, you have to ask yourselves, do you really believe the lockstep, bootstrap stories that are told by the others? The same story in the same words? I mean, even if it were true, wouldn't you think they would express it in different ways? Apparently that argument was persuasive. And the one Goldschlager story gave us what we needed to persuade the jury to disbelieve the Dirty Dozen. And so we got a verdict in favor of Ms. High School Clerk of $1 million, in part because of the weight of the handcuffs. When she spoke about the weight of the handcuffs, she broke into sobs. And of course, when a jury is evaluating a case for emotional anguish, that sort of helps. Of course, she had lost her job, so there were economic damages as well. It wasn't all just emotional anguish. But they took it up on appeal. And they lost on appeal. And then we got an additional award for attorney's fees. Why? Well, this is also an interesting mini story, which I'll tell really quick. Back then, these were the days of where your homeowner's policy covered defamation. It was the last days of that type of coverage for a homeowner's policy. And the mother had $300,000 of coverage. So the homeowner's insurance defended her. We had offered to settle for $300,000 many times, policy limits. They refused, which makes the insurance company on the hook if there's a judgment in excess of $300,000, because they can't foist that on their insured if they could have settled for policy limits. So the insurance company was now on the hook for the full $1 million, which means we were able to collect it. I mean, if we had just had a judgment against the mother and the kid, we never would have been able to collect. But we are not only able to collect the $1 million, but we were able to collect approximately $500,000 in attorney's fees that were awarded by the court. And so that was a lovely outcome for the client, for us, and for justice, truth, and the American way. Superman.
So the spy became Superman overnight.
The spy became Superman. Well, I mean, the spy was a decade or so earlier and was, well, I guess I was the spy. Well, I wouldn't say I became Superman, but my colleague and I shared the uniform. He had to deal with those pesky teenagers because I really didn't think I was going to be able to. And now that I have one of my own, oh God, I know I wouldn't have been able to.
Hey, speaking of yours, he's a working stiff now.
That is correct. My teenager has entered the realm of the working world earlier this week. He is working at Culver's, and he has the wonderful job of buttering the buns, putting on the condiments, having it toasted, and then handing them over to the griller to put the burgers on. And I asked him, are you doing anything else? He's been doing this now all week. He's had, I think, 4 shifts. And he says, no, that's all he's doing. Hour after hour after hour after hour, day after day. I said, I mean, they haven't taught you anything else yet? Nope, that's what I'm doing. And the funny thing is, he's excited about it still. He keeps asking for extra shifts. And I'm waiting for when it's become, I don't want to go to work today. Right now, it's just so fun and exciting and new. And I'm allowing him to get as many shifts as he can get. It's not school time yet. And he's counting the money as to how much he's going to make every week. And I'm just waiting for the reality of working a job day after day, for an hourly wage, and asking yourself eventually, is an hour of my time really worth X amount of dollars, or is it worth more than that? Now, the good thing is, he planned, his goal is to become a psychologist and, get a PhD. And so thankfully, finally, his head is on straight. So I'm glad he's in the working world, not only so he can make some money, but I wanted him to enter the working world, and he's been delayed because of COVID. I wanted him to enter it because I wanted him to learn some lessons I'd been trying to teach him, and he wasn't listening to me as his dad. I wanted him to learn that in the working world, you can't roll your eyes at your boss without getting fired. You can't mouth off without getting fired. That you've got to learn to say, yes, sir, no, sir, yes, ma'am, no, ma'am, right away, sir, right away, ma'am. And that's the way it is, whether you like it or not. They don't want to hear it from you. And so you may be able to get away with some of it back home. You're not going to get away with it with a boss. And that's life.
Is he going to work when he goes back to school?
Yeah, he's going to work. It's going to be his senior year in high school. He's going to graduate early in December. So a lot of his classes will be at IRSC, and he'll have a schedule that is fairly predictable. And so he'll do the working that he's allowed to do as a 17-year-old once school starts. And then come December, when he technically graduates, he'll have 8 months before college that he can work 40 hours a week, 50 hours a week, whatever the heck he wants in that or a different job that may pay more. But, I want him to earn the money. I want him to really learn the value of the money and what it costs and what it can buy and what it can do for you, but also to learn some harsh realities of the working world. And not just that you have to swallow your pride, swallow whatever it is you don't like, and, yes, no, but that hopefully this is not the life you want. I mean, fortunately, it's not the life he wants, but it's a difficult life working in any job that is an hourly job and where you often are working paycheck to paycheck, living paycheck to paycheck, whether it's retail or the food industry, or I told him my very first job was in a factory, an unair conditioned factory during the summer, where people literally were collapsing one by one, and the ambulance was coming every day. And it was at a plant where my mother was the bookkeeper, so they gave me a job. And I stood in front of different machines every day, and they would tell me, okay, here's a piece of aluminum. Put this in the machine, let it bend the aluminum, put the bent piece in this cart, take another piece, put it in the machine, and do this for 5 or 6 hours. I despised that job. I hated that job. I hid in the men's room to take breaks when they wouldn't give them to me. I earned $2.50 an hour for 40 hours a week, $100 gross. And I loved it only because I worked there 3 weeks. No, I worked there a month. Oh, wow, time is sure flown. I worked there a month. And this was the deal I made with my parents, who agreed to pay the tuition one summer for me to go to a debate institute at Harvard. And I spent 3 weeks living in a Harvard dorm, going to classes in Harvard classrooms, being in Cambridge, living that life, and realizing that even though I would never go to Harvard, this was as close as I was going to come. I soaked it up.
For a young person, that's an awesome town.
It is, my gosh, what a truly, truly wonderful experience that was for me. And if I had to work like that for a month to get spending money, that was the deal. We'll pay the tuition for the debate camp at Harvard, but we're not giving you a penny to spend. You want that? Earn it. And I earned it, sweating every damn day. So, there are lessons that parents want kids to learn, and it goes generation to generation. And, that's what's happening.
So is your son going to continue on in his junior year at IRSC, or is he going to move on?
No, he's going to move on. He has some Florida colleges in mind. And initially, since we have a couple minutes left, he was looking all over the country. He was looking in Canada. University of Toronto has a phenomenal psychology program. But, then I told him, we have this Florida prepaid. Use it in Florida for undergrad, because that's where you're going to get maximum value. And that's the least important degree you're frankly going to get if you're going for a master's and a PhD. So use that money here in Florida where you maximize its effect. And then for grad school, well, we'll figure out what combination of working and loans and daddy's money, will best work. And you try to get into the best schools you can get into. And so that's the plan. And we'll see.
Sounds like a good one.
I told him, you choose what you want to do. If you change your mind about psychology and you want to do something else, that's fine with me, as long as you have a firm plan and you move towards it. I've never asked him if he wanted to be a lawyer. I didn't want to put that kind of pressure on him. Let him be what he wants to be. Just be happy, be successful, be a good person. That's all I care about. So, next week we'll talk about a couple more cases. I'll give you a little preview. We had a 2-week trial in the old Fort Pierce courthouse over the Family and Medical Leave Act and a bank officer who was treated very poorly when she came back from FMLA leave after a child threatened to jump off the Fort Pierce Bridge. So that's a story with a happy ending. But that is a story, let me tell you. And we also have the case of the hurricane and the angry client. Maybe I should write a book. I don't know. We have a couple stories. And I don't know, maybe I'm into story time now. It's a little break from talking about the substantive legal stuff. And it helps me reflect a little bit and some later time. All right, there it is. There it is, the music. So by the way, folks, I hope you heard us better today. We're using a brand new microphone, a Blue Yeti, and hopefully it was easier for you to hear. And I'll be back next Friday for Ask a Lawyer. For right now, I'm Stuart Address. Have a good weekend. Have a good week. I beg you, please get vaccinated. Please. That Delta variant is going to kill you, and it's going to hurt us. Get vaccinated. Talk to you next week.
Ask a Lawyer every Friday right here on WPSL, Port St. Lucie. Talking the Treasure Coast, webcaster to the world. And WSTU, Stuart, Martin County's Heritage Station.